Hi, I'm Will Trackman, General Counsel of Mountain States Legal Foundation. With me here today is David McDonald, one of our attorneys, and we are excited to talk to you in another of our series of Courthouse Steps webinars involving today's decision in the Dobbs case, which related to abortion and the cases of Roe versus Wade and Planned Parenthood versus Casey. As you probably know, Mountain States Legal Foundation is not a law firm that deals in abortion or the cases that address the right to an abortion under federal constitutional law. However, David and I thought that there were some interesting parts about the decision that do relate to what Mountain States Legal Foundation does, mostly related to the doctrine of stare decisis, or whether old decisions can be overturned when the Supreme Court evaluates a new case and needs to reevaluate what it previously said in a case prior. So David and I are going to walk through what the court's analysis in Dobbs said about stare decisis and how it may be related to what Mountain States Legal Foundation does in the future. Obviously, this was a blockbuster of a case, but we are going to talk about the very intricate details of the procedure. But of course, we'll still make it entertaining and offer some color commentary about what the implications are going forward.
We're not going to be deciding the moral ethical case of abortion today, Will.
That's correct, David. We're going to just talk about stare decisis and the doctrine of precedent. So I'll just lay out, and then I'll turn it over to David, what the main factors are that the court describes. And they are fivefold. So the first is whether the previous decision was correctly decided. The second was the analysis that the Supreme Court used in order to reach that decision. The third is the workability of the prior decision. The fourth is whether that decision had a distortion effect or an effect on other laws or doctrinal areas. And the fifth is the reliance interests, or how much people took account of the prior Supreme Court decision and relied on that. And so what sort of upsetting of those interests would be at play if the Supreme Court went back on its prior decision and decided to flip course. So for the first topic, the nature of the court's error, what do you think, David? I thought it was an interesting way that the court said it's not just about whether something is wrong from the past. It had to be something more, something big and egregiously wrong.
Right, and I think that's interesting. As the court goes to great pains to mention that it's not just we disagree with Roe, so therefore Roe is overturned. The court goes to great lengths to discuss the reasons for why exactly Roe is so bad to be overturned. And one of those reasons, like Will said, was that it was egregiously wrong the day it was decided. And the opinion goes into this talking about the historical analysis or lack thereof in the Roe decision. It's misinterpretation of the state of the common law, American common law, at the time the 14th Amendment was ratified in 1868. Going through the history of abortion regulations in this country, to what extent was illegal or illegal, various states. And through all that analysis, the court comes to this conclusion that Roe wasn't just wrong on a couple matters. It was wrong pretty much across the board whenever it attempted to engage in constitutional reasoning, which, as many critics of the decision have said over the years, it does sparingly throughout. So that's one part of it. There's a second part of it where we're discussing the nature of the decision at issue. And this is something the court also talks about in the decision, Justice Alito mentions, is that stare decisis is something very different in the context of statutes versus the Constitution. So there's something that's often said as a kind of a truism in law, is that it's better for something to be settled than to be correct. And that's especially pertinent when you're talking about kind of general business regulations. If you're running a business and there's a question about whether you need to submit Form X or Form Y, it doesn't really matter the substantive correctness of whether Form X or Form Y is right. What matters is that you put your investment into one or the other. And it matters that you can predict what's going on. When you're talking about the Constitution, you're talking about people's fundamental rights, talking about the fundamental structure. It's a very different set of factors at play there. And when you're talking about the Constitution, it really does matter if you get it right.
And it's only the court, right, that can correct its own errors. So, for instance, because this was a decision about the Constitution, only the court can say, okay, we were wrong about the Constitution. Congress can't say, no, the justices got it wrong. We're going to do something different. Only the court can control its own ability to revisit those decisions. Well, you touched on the next factor, which is the quality of the reasoning. I thought there were a few interesting things that Justice Alito, we should mention, Justice Alito wrote the majority opinion as commonly thought that he would based on a prior Supreme Court leak. And one of his points is that the previous decisions in Roe and Casey that were being overturned had obvious analytical mistakes in them. So, for instance, on the issue of whether a fetus was viable, he made the point, well, that could depend on where you live. That could depend on any number of factors. And so we can't put a lot of stake into into decisions where the court was really announcing analytical principles that lacked a basis. What did you think about that part of the decision?
Yeah, I thought that was really interesting, and especially the way that Justice Alito describes the Roe decision as essentially a statute. In the way that when you write a statute as a legislature, you usually come up with, okay, here, what is the problem we're trying to solve? Here are the specific factors you look at for how to regulate this specific activity. And that's essentially what Roe is doing, is saying, what does good policy look like? And that was really the question. And that's kind of what Alito was taking those prior courts to task for. He wasn't even saying so much that your legal analysis was bad. He's saying, is you barely bothered to do.
Yeah, I totally agree. I thought that was an interesting point, saying that when Roe and Casey were talking about trimesters, for instance, that looks a lot like what a legislature would do as opposed to judges evaluating an individual case. So that's a great point.
Yeah. So that's, I mean, it's interesting because it's something that's come up in the conversation a lot lately, is that Roe's standard about what 12-ish weeks where it comes out is about where, if you poll the American public, they come out. But again, it's a product of a compromise, is generally not something you're expecting from a court decision so much as a statute.
Yeah. The third factor was workability. And here I thought Justice Alito was really homed in on whether something was predictable. And he took to task the most recent of these decisions, Casey, by saying that judges were applying what Casey had announced, the undue burden standard, very differently, and that it was always hard to tell whether a burden on an abortion was due or undue. And so that factor weighed against preserving those decisions. What was your reaction to that factor?
Yeah. My first reaction was thinking back, and there's a reason if you look at the other kind of 14th Amendment case law for issues other than abortion, you'll realize that the court doesn't really use undue burden as a test in any other context. It's been sort of quarantined to the abortion issue. And there's generally a reason for that. And it's because there's not a whole lot of content in that test, regardless of how you want the case to turn out. Yeah. Undue burden is a kind of a fuzzy standard. It allows judges, whether they're pro-abortion, anti-abortion, to kind of put whatever they think is undue in there. There's not a whole lot of content.
Yeah, it's a great point, right? Whether something is due or undue is going to be up to the personal feelings of a judge, and eventually 9 judges on the Supreme Court. The fourth factor was the effect on other laws, whether there's a distortion effect. And here I thought it was interesting. Justice Alito cited an opinion from Colorado, actually, where protesters were close to an abortion clinic, and there was a law restricting how close protesters could go to the abortion clinic to protest. And the court, in a previous decision, upheld that, saying that even though we respect the First Amendment and a lot of protests, in that case, we think that there's a special reason why the law is valid and it can use for protests. So that was interesting that Justice Alito pointed out that that the court had actually distorted its First Amendment analysis because it was treating abortion differently than other rights. Did you have a reaction to the work of the effect on other state laws issue?
Not as much. I thought that's a really interesting point, though. I think it really is interesting, especially that coming from Justice Alito specifically, because that's something that he actually expressed frustration with the court a few years ago with his other conservative, quote unquote, colleagues on that, or the Westboro Baptist protesting case. A very similar issue is Alito is one of the justices that has actually been fairly open to the idea of saying you can put restrictions on protesters in order to maintain the safety and the mental health of people going through traumatic experiences. So I think it's really interesting that he points out that as an issue, because that's something that he holds very dear.
Right, right. Now, the fifth factor is the reliance interest. Obviously, that's one where the dissenters were really emphasizing how long it's been since Roe was decided 49 years ago. But of course, Justice Alito had a different take on reliance. He said that the idea that something's been around a long time just generally is an intangible reliance interest and not something that people necessarily put stake in, because people often will have different circumstances, and people don't plan on unplanned pregnancies. It's an oxymoron in itself. So I thought that was interesting that you needed to have some more of a tangible interest at stake rather than just a general, it's been around a long time reliance interests. The dissents disagreed strenuously. Did you have a reaction on that?
Yeah, I mean, really, all the opinions doing on that particular score is bringing the jurisprudence in this area of law into agreement with jurisprudence through other areas of the law. So this is something that we may use the term reliance in a kind of general sense in our everyday lives, but reliance is a legal term of art. It actually means something. And as someone who's been dealing with trying to prove to courts about reliance interests of my client, it's not always an easy thing to prove.
Yeah.
And when the law talks about reliance, what they're talking about is a term is called detrimental reliance. It means you did some affirmative act to make yourself worse off because someone else made a promise to you, and so you've changed your actions. And when you're talking about reliance in a legal sense, you don't really see that in the context of abortion. And you see this in the dissent, doesn't quite get into details on it. It sticks to a more general sort of, people have created their lives and relationships on basis of dignity.
It's broader and less tangible.
Mm-hmm.
Well, so Mountain State's Legal Foundation doesn't do abortion cases. We'll just reiterate that. But we do cases involving stare decisis and whether previous precedents were incorrectly decided. We filed a brief just a few months ago in the Harvard and University of North Carolina affirmative action cases. Many people are aware that affirmative action to date has been upheld as constitutional in some cases. There's a 2003 case called Grutter, and a 2016 case called Fisher v. Texas, where the court said affirmative action is constitutional. And yet here we have a case that'll be decided next term in the 2022-2023 term addressing affirmative action. So that's one where I think Mountain State's work really is affected by the issue of precedents and stare decisis. David, you want to talk about Chevron or other areas where we might see similar situations?
Yeah, so there's another thing when I think of long-held precedents that may or may not be overturned soon, Chevron is the first one to come up. For those of you who may not be aware, Chevron is a case from the 1980s. It essentially says that where a statute is ambiguous, courts have to defer to the interpretation of the federal agency that's interpreting the statute. Essentially, it's saying that when Congress writes ambiguous statutes, they're implicitly delegating authority to make that determination to the agency. Therefore, it doesn't really matter what the court thinks is the best reading, as long as what the agency says isn't patently unreasonable. And this is something that's really been under fire for the last few years. Justice Scalia, who originally wrote the decision, he wrote Hour after that, but he signed on to the Chevron decision, had turned against it in his later years. Justice Gorsuch and Justice Kavanaugh have both been vigorously opposed to that. Justice Thomas has been opposed to that. So I think we might see something akin to that. We've seen other cases kind of chipping away at the edges. So that's a case that's been upheld pretty much universally for 40 years now, since 1984. But also a case that I believe was clearly and egregiously wrongly decided on the day it happened, and I think it's become unworkable working through the factors.
I was going to say, why don't we apply what we just talked about to Chevron and the idea of administrative deference? Is it workable? Is there a distortion effect on other laws? Are there reliance interests? Sounds like you've just addressed the first factor, which is the egregiously wrong factor. Any other takes on what we saw today applying to Chevron or other doctrines?
Yeah. So I think when they're talking about workability, they talk a lot about the undue burden standard, and Casey being this kind of magic 8-ball of a law, trying to figure out what it means. I think you can see that very often with Chevron as well, where depending on the personal preferences of the judge. It can either be a very strong restraint on what the agencies are allowed to do, or it can be almost a blank check. So you really don't know what you're going to get. Are you going to get a Judge Gorsuch, or are you going to get a Judge Breyer when you're talking about this? So I think under the standards that were worked out in this case, I think Chevron turns out poorly on that workability.
Well, that's good. I think we'll leave it on that note for the future. Optimistic. Well, thank you everyone for joining us. This is our second in a series of webinars on the 2021-2022 Supreme Court term. It's our pleasure to bring you some of our hot take analysis, courthouse steps analysis from the decisions, the big ones that have been happening the last 2 weeks. With that, we'll see you at the next one.